So this morning we are covering Form 22C, which you will see on my channel, an older version of the form, but they updated the form, so we're going to update our video. So this is a form you use anytime the seller is actually going to be a lender to the buyer. And in the example today, we're actually helping Laine, and we're talking about a commercial deal, but you can use this form for both commercial and residential. If you're using it for commercial, I would not use residential purchase and sale agreements, but I would use a commercial purchase and sale and add this addendum as the terms for the seller financing. So we're going to roll through the terms on this form. You'll notice it's 4 pages in length, and that means that it's long compared to other forms, but it's mostly because there's a few different ways you can structure these deals. And so depending on which way you're going to use, you can skip ahead to certain clauses or not. So, excuse me, I have a different video on the pros and cons of a lease option versus a real estate contract. So watch for that video if you want to dig into the more details, but let's dive in. So, limited use, buyer represents that the property will or will not be used for a residential dwelling. So in Laine's example, this is going to be will not. Seller is a natural person, estate, or trust, has not financed in the last 12 months, did not construct or act as a contractor for the construction of a residence. Repayment schedule does not have negative amortization. Financing is a fixed rate and is subject to reasonable annual lifetime limitations. These 5 bullets are because of the law against high risk mortgages. So when we went into the Great Recession, a lot of legislators believed that it was caused by predatory lending. And so they set up regulations under Dodd-Frank on a federal level, and then also at state levels under our RCWs that basically say you can't be chronic lender to people, because that tends to be the people that take advantage of others, right? So I could sell my personal residence and I could be a lender. I could carry the note. Seller carryback is another term you'll hear. But I won't have financed another sale of a property in the last 12 months. If I do not or do meet any of these requirements, or trigger any of these requirements, I should say, then I can't be the lender. So that's why they have these sort of limiters at the beginning to make sure that the person who is carrying back the note is not a predatory lender. Paragraph B, Washington State DFI waiver. If the property is used for residential, seller shall obtain a waiver from the DFI under RCW 31.04.025 subsection 3. Man, that's a lot to say, isn't it? If seller does not give notice to buyer that seller has obtained the DFI waiver, right? So if you don't know in any of these forms what sort of time frame to fill in, go ahead and use the default language. And Laine, in your case, it's not residential, right? So you're going to say NA, but I see you raised your hand. What do you got?
So this particular building is zoned commercial.
Okay.
It has a unfinished residential upstairs unit that the buyer will likely convert or finish into residential space, or residential space. But that's all hypothetical, right? So this does not apply for the sake of this contract.
That's right. So it is not being used for a residential dwelling when they bought it. So they wouldn't have to go pursue that waiver.
Okay, gotcha.
Paragraph C, limited practice board forms. The current version of any LPB form referenced below shall be attached as a blank form. So LPB is a group of forms that were basically migrated from commercial into our NWMLS because typically they were better forms. And so they basically just said, well, let's just use these forms that already exist and we'll put them under this limited practice board designation. So examples, and you'll see below, are things like a deed of trust, right? The deed of trust is a 14-page document, and our MLS didn't want to have to recreate it because it's already commonly used and in use. So they just use the LPB forms. So this is just a reference that if those forms are referenced in these 4 pages, then those forms have to be attached. So it makes a lot of sense, right? Attorney review. Buyer and seller are advised to seek the counsel of an attorney to review the terms of this agreement, and this agreement is conditioned upon review and approval by counsel for buyer and seller. Unless party gives written notice of disapproval, then this shall be deemed satisfied. So what they're basically saying is you really should have an attorney look at this stuff, but they're not saying you have to provide proof that you did. They're just saying if you don't raise your hand and cry foul, they're going to assume that you had it looked at and that you're okay with it. If buyer and seller agree to financing terms that differ from the terms in this addendum or an attached LPB form, including but not limited to making interlineations or otherwise modifying or supplementing any pre-printed terms in this addendum or attachments hereto or thereto, the parties shall have this agreement reviewed by legal counsel. If buyer and seller do not give notice of approval of this agreement by their counsel within 10 days of mutual acceptance, this agreement shall terminate. So big difference between the second half of this clause and the first half. The first half says, if you use these forms, you should have it looked at by an attorney, but if we don't raise your hand, we're going to assume that it's satisfied or waived, right? In the second half, they're saying, hey, if you edit this form, then we require that you have it looked at by an attorney. And if you don't give notice of approval, right? So this is passive. If you do nothing, it is deemed satisfied. This is active. So if you use these forms and edit them, then an attorney has to review it and give notice of approval, right? And if not, the agreement terminates, the earnest money goes back to the buyer and the deal is dead. So pay close attention to that, right? These forms give you the latitude to create the terms in any way you want. But if you start striking things and revising things, then you got to get an attorney involved. And they're doing that to protect the buyer and the seller, right? All right, paragraph E, prior indebtedness and security. Seller understands that seller's security interest in the property may be inferior to a third party's interest in the property, such as a prior lender. Right? So if I carry a note, let's say Lawton is buying my house and I'm going to be his lender, but I have a mortgage. Well, if I secure my portion of what I'm lending him with a deed of trust, that deed of trust is going to be in second position because I already have a deed of trust in first position, right? So they consider that subordinate to the first party interest. So that's just making sure, and in the end, buyers and sellers sign all this stuff. So that means the seller has acknowledged that their interest could be inferior, right, or subordinate to a third party. All right, payments to the seller and payment method. So paragraph A, down payment. Buyer shall pay a down payment, including earnest money, which shall be applied to the purchase price as follows. So let's just use some numbers just to pretend, right? Let's say they're going to put 10% down and the seller is going to carry the other 90. What kind of purchase price do you think they're talking about, Laine?
So I have the numbers. Hold on one second. Earnest money, we're going to do 10,000.
Okay.
And purchase price is 607,941.
Of course it is.
Because they want to roll the taxes and insurance for 2021 into it.
607,941 times 10% is 60,794.
But they're actually going to do 20% down.
All right, we can do it that way. Times 2 is 121,588. All right, because earnest money plus additional down is 121,588, right? So that's their 20%.
Mm-hmm.
Does that make sense?
Yep.
All right. Interest. The balance of the price shall accrue at an interest rate of X. Did they decide on that already?
Yep. 5%.
5%. Typically, that means accruing from the closing date. They didn't agree to some variation of that, did they? Sometimes people will say, can you help me out and not charge interest for the first 30 days, you know, as an inducement to do the deal or something like that. So you could modify that. Payments to seller. Now, they have three choices. There can be no payments, right? And so in that example, interest would accrue and they would just have a balloon payment at some point in the future. They can make principal and interest payments, in which case you'd need an amortizing calculator to figure that out, or it can be interest only. Have they decided that yet?
Yes. So total monthly payment is $2,852.46.
Is that amortizing?
Yes.
So give me the number again. 2,800.
52 and 46 cents.
Right. And they're going to make payments on the first day of the month.
Yep.
And typically that has to start at least 30 days away. So it wouldn't be December 1st, it'd be January 1st. Have they talked about that?
So they wanted to do a 45-day close. So then would it be 30 days past the closing or past the mutual?
No, after closing. So if they close in 45 days, they're closing in January?
Yeah, call it, January 2nd.
Right. So the first payment wouldn't be February 1st, it would be March 2022.
Yeah.
And shall continue on the first day of each succeeding calendar month. Right? If they're going to pay monthly.
Okay.
Now, this is where you have to decide, are you doing a note and deed of trust, a real estate contract, right? You have choices. Now, the safest and most common choice is a note and deed of trust. So a promissory note is exactly as it sounds. It's a promise to repay a debt. And then the deed of trust is the security instrument that secures that obligation to the house and creates collateral. The house becomes collateral for in this case, the restaurant. So promissory note and deed of trust would be the smartest thing to choose. Real estate contract, again, I have a separate video on this topic, but I'll give you the very short version here. A real estate contract can be an effective means to do something, but then you have to decide, are you going to record it or not record it? And if you record it, that makes it safer for everybody as far as not, risking getting screwed over by the other party. But the problem with recording is it triggers a due on sale clause if the seller has an underlying mortgage. And so that's why people have to really be thoughtful about whether they're going to do that or not. So in our example, we're going to use promissory note and deed of trust. Does the seller have an underlying mortgage, Laine?
No.
All right. So then this is going to be a first lien position deed of trust, which is cool. That makes it easier, right? Less risk. Promissory note, we're going to use LPB form 28A, right? So we can take a look at that in a separate video if we want. Deed of trust. We're going to decide between two different deeds of trust. One has a due on sale clause, and this one does not. So if I'm the seller and I don't have a mortgage, I would want a due on sale clause. And I'll tell you the reason why. If I sell my house to Laine and then Laine sells the house to someone else, right? Then I have now become the lender for someone else whom I don't know. And I've done no research. If I'm doing this for Laine, even though we know each other, I'm still going to look at his credit. I'm going to look at his income. I'm going to figure out, can he afford this? Well, if he sells it to some schlep that doesn't have two nickels to rub together, I would never have approved that, right? So that's why I want to have the authority to call it due if he does that. If I use this one, then he could sell it and I just have to pray that the payments continue. Does that make sense?
Yeah.
All right. Due date, balance of principal and accrued interest shall be due and payable in full on, do you know how long they want this to be?
So they want to do a 5-year balloon.
A 5-year balloon. All right. So if they close on January 5th or whatever it happens to be, right?
Mm-hmm.
And we could say on the first day of February 2027, right? So that would be 60 months, and then the first day of the month that follows the 60th month. Make sense?
It does. It does. I did just notice they wanted to do a 25-year amortization schedule, but that shouldn't change anything, right, from what we did?
Right. That's that's how they arrived at this dollar amount right here.
Right. Right.
So there'll be a balloon due on the 27th, and they'll have an amortization schedule that tells them what the balance is on the first day of February 2027.
Mm-hmm. Okay.
So that is a 25-year due in 5 loan.
Okay.
Right.
Yeah.
Then you have default interest. So 18% is the most allowed under state law. The usury laws limit how much interest people can charge. And so you couldn't charge more than that, but you could charge less. The reason I'm saying all this is because it depends who hired you, right? If in Lawton's case, the seller's the one that hired him, right? So he's probably going to say 18%. But if it was the buyer that reached out, you might say, well, let's see if we can make that lower, right? Because A, we're hoping the buyer doesn't intend to default, but if they do, we don't want them to get hammered by default interest, right? Now, late payments, there's usury laws about how much can be charged, right? 5% of the payment. Sometimes you say it'll just be $150. What's 5% of that mortgage payment is $140 actually, right? 2,800. 5% of 2,800 is 140. But you could do either. So just talk to your client and see what they want.
Okay.
Right? You also want to talk to them about when do you want it to be late. So typical residential lending, payment is due on the 5th, late on the 15th, but it doesn't show up on your credit report as late until after 30 days. So you just have to talk through that with your client. A lot of times your clients are going to say, I don't know, what's normal? What do you think, right? And in those cases, use the default.
Mm-hmm.
If buyer's not cured of default within 30 days after written notice, seller can declare all sums due and payable. So that accelerates the note. So if a buyer is late, they might trigger a late fee, but they aren't losing leverage with the seller. If they're more than 30 days late, then they are. Does that make sense?
Mm-hmm.
Paragraph 6, buyer can prepay at any time, right? That's part of the Dodd-Frank rules. You can't have prepayment penalties any longer. No further encumbrances. So this is a checkbox because there might be a reason why the buyer and seller have already talked about the buyer's going to go get a home equity line of credit, let's say, or a line of credit to run the restaurant. But if they haven't had that conversation, the seller would prefer that they not erode the equity further by getting another deed of trust, right? Because we chose note and deed of trust, we don't have to fill out any of the real estate contract part, right? So we're going to skip this, but I'll cover it for the video, right? So if you didn't use note and deed of trust, then you would check real estate contract. Remember to have the conversation about whether you intend to have it recorded or not. The parties agree to initial and make applicable the following optional provisions, LPB Form 44 of the corresponding box, right? So substitution and security on personal property. So I could buy your house and wrap, like a restaurant's a good example. I could wrap the equipment in the kitchen and make it part of the collateral, right? That's making it a security against the equipment. Alterations to the building, if we were going to discuss those. A due on sale clause, we kind of feel like we should do that if we represent the seller. Prepayment penalties on prior encumbrances. So that's a disclosure, right? If I have an underlying mortgage that has a prepayment penalty, that would affect the buyer because they couldn't pay it off early without triggering that penalty. So it's been, 13 years since the Great Recession. So there aren't a lot of existing mortgages that have prepayment penalties, but there could be. So that's why that's in there. Periodic payment of taxes, insurance. Who's going to pay it and when's it due by, right? Those are all things you want to have very clear and upfront. And in your case, Laine, because we're using note and deed of trust, there's a section below that we'll talk through, which is contract collections, right? And then cash out. So I did a real estate contract. I had these modifications to the contract, and then I had but in all cases, you're going to pay me off no later than February 1st of 2027 is the example we're using, right? So that would be memorialized in the real estate contract. But again, we're not using that. So you're just going to skip paragraph 2, I think, isn't that paragraph 2? Or section E of paragraph 2. You with me?
Yep.
All right. Assumed underlying obligations. So if there are any, then you have to decide, are you going to assume them, right? In our example, there aren't any, so that doesn't apply. That would also mean that none of these other clauses apply to your situation, Laine, but I'm going to cover them for the video, right? So let's say you had a mortgage and the buyer wanted to assume it. Well, there's a good likelihood that the underlying lien holder doesn't allow an assumption unless it's a formal assumption. And a formal assumption means that you have to have the buyer make application to the lien holder to get their consent. A seller wrap means we're not going to tell my lien holder, and I'm just going to carry your note outside of my mortgage obligation. And the reason I can do that is the presumption is it's gone up in value and I owe less than you're paying me, right? But the economics could be that, maybe you need the buyer to put a certain amount down to pay down the mortgage so you can carry the paper. Like all of these are numbers, right? So you have to analyze each of them on a case-by-case basis to figure out, can we just do a wrap? Or do we have to put money down to buy down the balance of the mortgage? Like that, an example of that, an obvious example would be if I had a negative amortizing mortgage or my value had gone down like they did in 07, 08, maybe my mortgage is more than what I'm selling it for, right? I'm a short sale. Well, in that instance, the buyer would have to have a down payment in order to make it work. So none of this applies to Laine's example, so we're not going to worry about it. This is a continuation of that same down, right? Seller, if we're messing around with the seller's mortgage, the seller has to warrant whether it can be assumed at all, right? If it's going to be assumed, the buyer should have the opportunity to review the note and deed of trust because they're going to take on that obligation, right? And the seller should have an opportunity to see if they have any trailing liability, right, under an assumption. Because that's the most common thing that happens is the lender might say yes to Laine assuming my mortgage, but they're not going to let me off the hook. If Laine fails to make payments, they're going to come after me. So that's what they mean by remaining liability. All right, so none of that applies to Laine's example, but paragraph 4 could apply if they chose, right? So paragraph 4 says, do we want to use a collection account? And I always use a collection account, and I use AFTS Collection Services. They're national. They've been around for decades. They do a great job, and they're right here in Seattle. So I would consider using them. And then what I tell people is there's a setup fee that will be split by buyer and seller, and then there's a monthly fee that will be split by buyer and seller. So it's like $250 to set it up and $10 a month to service it. So that means buyer and seller are each going to pay $125 to set it up and $5 a month to process those payments. Does that make sense, Lawton?
It does. Yeah. Does the to be established and paid for by buyer and seller equally, is that a continuum throughout the contract or just that setup fee?
No, it's throughout the contract. But
Okay.
you could also say, no, we want the seller to pay it. You know, seller could say, I'm going to pay 75%, the buyer's going to pay 25 or whatever.
Okay.
But most commonly, what's most reasonable is that it's just split.
Okay.
Closing agent may or may not collect collection account setup fees and annual escrow fees. So the smartest way is to say, yes, we want this all set up at the closing table, and we're going to have escrow be a part of that, right? Now, the collection account can also serve as escrow for reconveying an underlying mortgage, paying taxes, all kinds of stuff after the closing happens, right? So you have to decide, do we want them to handle those payments? And in most cases, the answer should be yes, because as a buyer, I'd be very nervous if the seller was going to handle those payments, because if they don't, I could get screwed, right? Closing agent may or may not collect the initial deposit for taxes, right? So you always want to say may if you're going to have them do that. And that's a kind of complicated calculation, but the way you want to think about it is, if we're closing in January, the first half taxes are due in April. Well, if I pay 1/12 of the taxes with each of my monthly payments, then by April, I'm only going to have 4/12, right? Or 3/12, because I had February, March, and April's payments. So 3/12. That's not enough to pay the taxes, right? So that means escrow has to collect up front 3 more months worth of taxes, so that when April rolls around, they've got 6 months in a reserve. And actually what they do is they collect 2 extra just in case. So they would collect 5 months of taxes in order to have 6 months available when April rolls around, but have 2 left over. Does that make sense?
It does. Does all escrow companies, they're willing to be a part of a long-term hold like this?
Well, no, escrow companies don't do this.
AFTS does it.
Yeah, so escrow companies will collect it on a normal closing, but then they give it to the lender. So the lenders have what's called an impound account. And so they impound for taxes and insurance. And so they would give the lender those 5 months. And then the lender's the one that receives the February, March, and April payments. So then they make the payment for the taxes. And they do the same thing for the insurance, but that's annually, right? And it typically gets paid at the closing. And so they only have to collect 2 months, or maybe it's 3 because you skip a month, but they only collect a couple of months at the beginning because there's going to be a year's worth of payments before the insurance bill comes due again.
Okay.
Right. Seller's review of buyer's financing contingency. So this is where you're giving the seller the legal opportunity to look at the buyer's income and credit and all of this, right? So I would say 2 years, employment, other, I would look at bank statements, down payment, source, something like that, document down payment source. Buyer will provide seller all applicable information, including credit report and score, within blank days. So you could make that faster, shorter, whatever. Unless seller gives written notice to buyer of disapproval within 2 days of receiving, right? Or 2 days of the date the information is due. So if the buyer turns it in late or not at all, the seller can just terminate the deal, right? Oh no, sorry. The contingency is deemed waived if the buyer doesn't turn it in. Right? So the seller would terminate if the buyer didn't turn it in. They would give a notice of disapproval, right? Because they didn't provide tax returns, credit report, etc. Title insurance. So when there's not a formal lender involved, there isn't a mandate or a requirement that title insurance be obtained. You should always get title insurance. There's too much risk. The reason people don't like title insurance is because they don't understand it, and it costs typically $1,000 to $2,000. Well, the problem is if there is a title issue, you can add a minimum of a 0 to that number. It's usually a 5-figure problem, right? So 10, 20, 50 or more $1,000. So I would always get title insurance and encourage both buyer and seller to do so. So that's the end of the form. I'm going to go back to the beginning just to have it on the screen while we talk. Do you have any questions, Laine?
I don't think so.
All right, then I'm going to stop the recording.